I'd now like to introduce the topic for today's session, Forensic Investigative Legal Challenges with New Cyber Regulations. And with that, I'll hand it over to our moderator. Thank you.
Thank you. Good morning. I'm Lynn Brown. I'm a partner in the Washington, D.C. law firm of Wiley Rein in the Cybersecurity, Privacy, and Data Governance Practice Group, and I'm happy to be your moderator today. First, I'd like to ask our panelists to introduce themselves.
Hi, I'm Erin Joe. I've held positions at the Office of the CISO and Google Cloud. I was a Senior Vice President at Mandiant, and I was an executive leader in the FBI, and I am an attorney by background. And I've been working with the private sector and governments around the world for over 2 decades on advancing security practices and modernizing technology.
Good morning. I'm Jennifer Burnside. I'm a practice leader with Mandiant's Crisis Communications team, now part of Google Cloud Security. I'm glad to be with you today. As part of our practice at Mandiant, I help actively respond to incidents for our customers, as well as proactively plan and prepare and test those playbooks and plans as part of our process. Similar to many of the panelists today here, I'm also a former FBI and glad to be here with you.
Hey, good morning, everybody. Thanks for spending your morning with us here today. My name is Mike Mochtinger. I'm an executive in the FBI's Cyber Division. And really, I'm focused on incident reporting and analysis, as well as governmental partnerships.
Thank you. Today, a variety of cyber incident reporting obligations are raising complicated questions for investigators and for legal teams regarding materiality, privilege, and law enforcement coordination issues. This is a very fluid area right now. We have new cyber incident reporting rules, we have additional proposed rules, and we have a change in presidential direction to a more deregulatory approach. This means we may soon see changes in current and previously proposed rules as the Trump administration reviews and rescinds a variety of executive orders and agency actions as part of its regulatory freeze and regulatory reduction efforts. So let's go through some of the major cyber incident reporting requirements. As of December 2023, new SEC rules mandate that public companies publicly disclose material cybersecurity incidents within 4 business days of determining that the incident will have a material impact. The deadline is not 4 days after the incident, but 4 days after the company determines that it is material. The SEC said the rules are aimed at providing investors with the information that they need to make informed investment and voting decisions. A material cybersecurity incident is defined as one that a reasonable shareholder would consider important in making an investment decision. Disclosures may be delayed if the Attorney General determines that the immediate disclosure poses a substantial risk to national security or public safety and notifies the SEC in writing. Next, the Department of Defense has regulatory requirements for defense contractors to rapidly report a cyber incident within 72 hours of discovery. A cyber incident is a compromise of a computer, a network, or an information system. And finally, the Cybersecurity and Infrastructure Security Agency, CISA, proposed rules last March that require critical infrastructure entities to report cyber incidents within 72 hours for a covered cyber incident and report a ransomware incident within 24 hours of payment. The rules define critical infrastructure entities broadly, and comments on the proposed rules were extensive and focused on the breadth of coverage and the cost of compliance. Final regulations are supposed to be issued by October of 2025. The new Trump administration and its decidedly deregulatory approach is reviewing a variety of these regulatory requirements as part of the regulatory rollback efforts. So the future of this proposed rule is currently quite uncertain at the time. So with this background, Erin, I want to turn to you first. How are the new cyber regulations impacting forensic reviews and investigations?
Sure. Well, as everyone in this room knows, incident response is difficult even under the best of circumstances. So now some of these regulations are potentially bringing conflict into an organization with respect to priorities, and the impact is going to be on your resources, your time, and your recovery. And we already know that there's a great demand for information flow during an incident response. And that demand now will just continue to increase because different people in the organization are trying to make these determinations of materiality, and if one is made, then they need a whole host of additional facts to comply with the reporting requirements. So now on your investigative team, you're saying, hey, not only do I need you chasing nation-state actors and criminal threat actors, but now I also need you reporting on a continual basis what you're finding so that I can make these determinations and get the details that I need if I have to make a report. And that's a big strain. And it also calls into question some of these legal versus operational tensions because you're trying to get your business back up and running, but you're also trying to meet these legal requirements. And depending on the size of your team and the resources available, that can be very challenging. I think it's more important now than ever to really talk about the scope of the investigation and really consider thinking through how you're going to scope these investigations, because if it's too narrow, you might miss another infection, or you may miss something else that was critical to be disclosed at a certain time. And that's going to be more important now than ever, given these requirements. And I think 2 years ago, Mandiant reported that in 27% of the cases that they were in, they found multiple threat actors in a single victim environment. And last year, about 8% of the time, they found that the initial infection vector was from a reinfection of a prior incident. And about 35% of the time, they find malware with backdoor capabilities. So these are the types of things that you need to think about when scoping your investigation, because you could miss something that could lead you to just having to making another disclosure later, or reporting information that would show that you missed something that maybe you should have caught earlier. And that's really hard on investigations. And we all know that over time, you learn more. And as you learn more, those circumstances change, and you have to be prepared to be flexible and update your report, because what you report initially may change over time, and you have to update that report. I think Microsoft had a really interesting situation because they had an intrusion on some of their employee emails. And in their evaluation, they said, you know what? This is material, because a reasonable investor would care that these emails have been compromised. But as they went through what they are required to report, they said, okay, well, looking at this in the investigation, they did not find that it impacted the financial condition or operations of the business. So if that's the end of it, that's the end of it. But if in the future course of their investigation that changes, then they would have to modify that report. So these are really important considerations to be thinking about, not just at the moment that you make a materiality determination, but over the course of time as details unfold. So I think the call to action here is really about, one, taking some time to think through the scope of your investigation and think through how the data that is out there about how these threat actors are acting and how that may impact the scope of that investigation. And then two, start to think about the fact that now there's additional scrutiny around what you are doing in your organization with respect to that forensic examination. And the questions will arise, who knew what and when? So you really need to be thinking carefully about that as you progress, which just adds another layer of complexity to the investigation.
Thank you.
Yeah,
Mike?
I mean, if I can just pick
Oh,
up
sure,
where,
please.
Aaron left off on
Yeah.
the complexity standpoint, right? I'm one of the non-attorneys on the panel. I don't know how many of you are attorneys in the room, but I would suspect that many of you are not. And this is a very complex landscape to navigate, and this is where you really want to lean on your internal legal, your external legal, because not only related to scope, but on the determination of materiality, right? So, as you're thinking about it and recognizing change is constant on this regulatory landscape piece. And so what may be today's rules may not be in 1 or 2 or 3 weeks or so. So again, making sure you truly understand and seek that legal expert opinion. Because no incident's going to be the same, no decision's going to be the same on when to report, and it's going to be specific not only to the organization, but also specific to the incident and what may be at hand. And if I could just scope around the considerations for you, what I'll call the 3 Ps. The first P of which is planning. You know, that you as an organization have thought about your strategy, that you've recognized who are the important responders who will be part of that, who are the system owners or business line folks that you want to bring into play as part of that. And then not only from your internal CMT responder standpoint, but who are all those other external entities, whether it's your suppliers, your vendors, or your partners that you may need to bring into fold. And this is going to be particularly in consideration a little while when we talk about DoD and some of the defense-related regulations. Second P after planning is around prioritization. And this is one of the elements when it comes to tensions that really can be highlighted in an organization that hasn't planned well. So multiple competing priorities that are coming into play may not be in line with what the IT or cybersecurity team is looking at. For example, your CISO or your C-suite, they're mainly concerned at first about when are you going to get systems back online, right? They also are thinking about customers, and that brings me to sales. Sales is thinking about what can I tell my customer, right? And you want to make sure that the communications don't get ahead of the investigation or the reporting as it's required. The third element is obviously legal, and whether or not there may be, again, considerations when it comes to not only the forensic artifacts that you're capturing, but also the potential for litigation. So your lawyers are definitely going to weigh in and during an investigation. And then comms, they want to share the good news, right? And it's about what you're doing, but also to help on some of those public inquiries that you're getting. So those are the internal prioritization that you're going to think about. But we also have got to think about the external entities. You know, obviously partners, suppliers, vendors, regulators, law enforcement, but there's someone else who gets a vote in an incident. And that's our threat actor, right? The threat actor can turn and use the public domain. So we have to prioritize and sequence our communications and our actions so that A, we don't tip our hand to the threat actor that they could exploit, or B, that the threat actor takes advantage of the situation. The last P is around the people. You know, responding to an incident, it's an emotional response, right? Not only your first line responders who are fielding the inquiries and the taskers that are at hand, but also as you start to talk to your suppliers, your vendors, your partners. One of the things we like to suggest is try to get it written down and anchor on key statements. I'm not saying press release, right? I'm talking about making sure you're consistent. And so that same messaging that the C-suite may share up to the board is also shared to your sales team as appropriate for downstream customers and the like. So these are, again, some of the things when we're thinking about around materiality that we want to make sure we've got those 3 Ps, the people, the planning, and the prioritization all spelled out.
So, Mike, from an FBI perspective, what are you seeing with respect to cyber incident reporting regulations? What impact are they having on FBI investigations?
Yeah, so I think the main thing that we would be concerned about in this type of environment and with various requirements coming and going, as you guys have explained, is a chilling effect on impact or on engagement with the FBI. We've not seen that chilling effect, and I think that's a really good news story for us, and I think it's a good news story for cybersecurity. And I think what we are seeing is our partners in the private sector, having an increased understanding that engaging with us early and often is actually something that reduces risk. And what we really want to do is make it second nature for you to come to the FBI when there's a problem. And it should be more of a phone a friend option than something that you feel you have to do. We're hopeful that those relationships exist in the good times before there's an incident so that they can be leveraged to your benefit in the times that there is an incident. And I think, as we're talking about the regulations and the reporting requirements, these are going to continue to evolve. As a government and as an industry, we're still working to find the right equilibrium here, right? There's going to be different preferences among different administrations as they come and go. But I think what is not going to change is the fact that the FBI is a victim-centric organization. Our cyber mission is victim-centric. We want to understand and mitigate threats. We're not looking to share proprietary information that you provide to us. And that's a misconception. I'm sure we're going to talk about it more as the day goes on, but that's something that I really want to put to bed today. The information that you provide to us, we only share it with those who need it. We share it in ways that protect those who give it to us. And as a rule, we do not share it with regulators.
Thank you. So let's talk a little bit more about the SEC's requirement to publicly disclose a material cybersecurity incident within 4 business days. With the new reporting requirements, some say there's been a rise in tension with CISOs. The SEC announced charges against the software company's CISO for fraud and internal control failures relating to allegedly known cybersecurity risks and vulnerabilities. The SEC alleged that the CISOs overstated the company's cybersecurity practices, failed to disclose known risks, and then made incomplete disclosures about those about a cyber attack on the company's 8K. So the court dismissed a lot of those claims that the SEC was bringing, particularly for the post-incident conduct, but some of the pre-attack claims regarding disclosures were left pending. And so it leaves open it leaves open a lot of questions right now about potential liability for CISOs, and I wanted to get your opinion on it, and about the responsibility for corporate statements regarding the state of a company's cybersecurity posture. So what challenges are you seeing with the SEC's materiality determinations? What challenges are they posing for cyber investigators, and what challenges do you think they're posing for legal counsel, and what tensions are you seeing because of these materiality determination requirements?
Yeah, Lynn, you probably remember this is actually the impetus for us to do this particular panel, right? Because last year we could foresee the dangers of divergent views. We were very concerned about what that could mean for security professionals and what it could mean for organizations, because these are really hard and challenging times that they're in anyway, let alone if you have divergent views that can cause potential liability, regulatory issues, or even criminal allegations and convictions. So these are very serious concerns, and I think about it in a few ways. One, internally, right? So those internal conflicts, and it could even include a conflict in the fiduciary duty, because as we've been saying, you have conflicting obligations, one to get your business up and running, and then the other is to comply with your legal requirements. And then two, to your point, the divergent views that could arise between your CISO and your legal counsel or other individuals within the organization. And that can become particularly troubling when you start to think about who knew what and when, and whose responsibility was it to make the decision, and how does that impact the individuals, not only the organization. So here, the call to action here is get those clear lines of reporting and decision-making in place so that you know who in the organization is responsible for making the materiality determination and for making the reporting and meeting those requirements. But also, you want to have a deliberation process in place so that you're documenting which of the facts you knew at the time, how those things unfolded. You need a timeline of those events. And if there are disagreements, you want to be able to document the reasoning for a particular decision. That's going to be very important. And I know now we are seeing cases where CISOs are doing a lot more documentation along with the legal team as well. And these are situations where even CISOs are starting to seek their own legal advice, because it's putting them in a very difficult situation if they're not the ultimate decision maker. If a decision's made to disclose earlier than maybe what a CISO might make, then there's probably less of a concern. But if the CISO's saying, no, we need to make a disclosure, and legal counsel hasn't made that determination yet, that could really be a very serious potential conflict. So those are the internal conflicts that we're concerned about. The external ones are the ones where, what if the SEC disagrees with you? What if you think that your clock started to tick at a certain time and the triggering event started at a certain time, but then when you actually make the disclosure, the SEC disagrees with you and thinks that you should have made it much earlier? and that the facts were supportive of that. That's going to be another potential conflict area. So that documentation, those processes, the deliberation process is absolutely critical to keep track of. And then the other thing that I can start to foresee and that we're already seeing is calling into question your due diligence. And when these investigations are happening, let's say from the SEC and then potentially others, they are looking at all of your security practices that come with those disclosures. And then if they decide to have an investigation on that, based on those disclosures, additional information is likely to come out. So you want to make sure that you are very well positioned to be able to demonstrate your fiduciary duty, due diligence in how you've approached this, reasonableness in how you've been approaching the investigation, and then also that you can demonstrate strong security practices overall.
Thank you. So the SEC rules also include a national security exemption that allows companies to delay public disclosure if the Attorney General determines that immediate disclosure would pose a substantial risk to national security or public safety. And we understand from the Department of Justice last year that there have been several times where this exemption has been utilized. So Mike, I want to ask you about this process. Can you explain how the national security or public safety delay process works? What does a company have to do to request a delay, and what role does the FBI play in that process?
Yeah, that's a great question, Lynn. So first of all, as you mentioned, the FBI itself, we do not make delay determinations. So that is the Department of Justice. But when you provide information to us, we can help DOJ understand national security implications to allow them to make a determination on an initial 30-day delay and, of course, any follow-up delay requests. So I think that's, again, why it's important to engage us as quickly as possible. If you believe that a disclosure of an incident may pose a risk to national security or public safety, coming to the FBI so that we can understand the context surrounding the incident before a determination of materiality is made and a delay is requested, then we'll be that much more prepared to provide the right context to DOJ to consider the request. So, and another thing I think that's important to note is that when you come to us and engage with us after a cyber intrusion, that in itself doesn't trigger any sort of determination of materiality. It just allows us to better understand the context, to better help you, and to better be able to provide information so the DOJ can make that informed decision. As far as actually filing a report or filing for a delay, there's instructions on our website at www.fbi.gov/SEC, and I think just as engaging us early is important, the moment that materiality is determined, please, if you're going to seek a delay, get on that website, do that immediately, because with the timelines involved that we've just talked about, the delay request could be declined just because it's not presented in a timely manner and there's not enough time to properly consider it.
Thank you. Those are important timelines to remember. I want to turn next to the Department of Defense. Government defense contractors are required to report cyber incidents to the Department of Defense within 72 hours. The reporting requirements include describing the type of incident, the detection method, there are preservation requirements. The amount of information required really can be quite staggering for a company that is in the initial stages of an investigation. Is at least one of the common complaints that we've heard. What impact, Jen, I want to direct this to you, what impacts or challenges are you seeing with DoD's rapid reporting requirements?
Yeah, 72 hours goes by really quick, first off, right? And again, when it comes to the defense industrial base or the primary defense industry folks, with it being a highly regulated industry, it's understanding not only the DFARS, but all of the contractual provisions that apply, both not only NIST 800-171 and ISO 27001, but also, what are the specific provisions in the contract that not only apply to you as the organization or as the prime, but all of your subcontractors, right? We'll call that, as it's known in, the lawyers will correct me, but the flow down clauses roll down not only from the prime, but all the provisions of that contract roll down to also the subs. So if, for example, a sub has an incident, right, they're going to also have to report within that 72 hours. So what comes into play is, do you as an organization understand and have a strong vendor management program and understand for your subs how an incident's not only going to be monitored but analyzed, triaged, and reported up to you as well as the Department of Defense, right? So this is where that provision really comes into play, and that you as an organization would have, you know, like I said, a well-oiled machine to navigate. Because the downside, right, if you don't get it right, there's multiple ways that could come into play as you're navigating this labyrinth of regulation. The first of which is cost, right? And the fact of, from a contractor standpoint, you could potentially have your contract suspended. It could be terminated. You could face fines or even penalties. And you could also be blacklisted. The second area is from a reputational standpoint. Even as you, as the primary organization, if it's one of your sub that's impacted, you know, the story could be about your organization, right? Because if you think of it like the umbrella, you're at the top of the umbrella managing and keeping the rain away. So you need to make sure, again, that they've got a way and know what to do in the event of an incident in order to comport with all of which Lynn read off in her description of the elements. And then the last thing, and for me as a former public servant and as a mother of an Army lieutenant, you know, the fact is it's operationally important as well, right? You're not only helping the warfighter, but it's the systems and all of the intellectual property that goes along with a lot of these DoD elements. So those are some of the things really when it comes to that 72-hour reporting requirement that I'm really thinking about.
Thank you. CISA also has proposed rules with, again, a 72-hour reporting requirement for cyber incidents, and then a 24-hour reporting requirement for ransom payments, not the attack, but the ransom payment. This is part of the public notice and comment rulemaking process. Comments were due by any entity that wanted to file comments back in March. The proposed rules by legislation are supposed to come out in October. CISA received over 300 comments from a wide array of trade associations, companies, state and local governments representing various aspects of critical infrastructure. A lot of the comments focused on the broad reach of the proposed definition of cyber, covered entity, critical infrastructure entity. The U.S. Chamber of Commerce has estimated that the definition could possibly extend to cover 300,000 entities, which they also said is beyond the scope of what they believe Congress intended when it passed the original legislation mandating the rules. So, Mike, what are the potential impacts of the CISA's proposed reporting requirement rules on the FBI?
Yeah, so first when we look at this and sort of frame this, you know, we know this is a really crowded space, and the government has got to do a better job of communicating amongst ourselves with each other and making things less confusing and cumbersome for the private sector. That's without any doubt, that's the lens that we're looking through CIRCIA and all these other regulations with. We've been working really close with CISA to that end to make sure that we have access to reporting collected by them pursuant to CIRCIA. We've been working through our counsel to understand what the FBI's obligations are to inject into CISA reporting that we might receive that may meet the standards of CIRCIA. And all of this is important so that we've got a common operating picture. And as I said, we need to do better. We need to be able to deconflict victim engagement. We need to be able to deconflict our investigative activities when federal laws are broken inside of the government, probably, you know, better than we have been doing. You know, as you said, Lynn, all of this is up in the air right now as far as CIRCIA goes. And without a final rule, it's really tough for me to forecast what our specific policies will be. But what I can assure you, again, is that we're focused on victims. We're focused on simplifying your engagement with the government. We're focused on making sure that we are talking amongst different elements of the government to best serve victims and to best serve the industry. And whatever the final rule comes out as, and you know, however it's implemented, none of that's going to change.
You know, just very quickly to add on to that, we've been talking quite a bit about these different individual reporting requirements, and they are from a different perspective and lens. So as much as you might try to reach alignment, what an investor cares about might be different than what CISA and DoD care about from a national security or critical infrastructure standpoint. So we may not achieve perfect alignment, even though there's certainly good reason to try. But I just want to take 1 second, because we haven't talked yet about, you could be a single entity that is subject to all 3 of these or even others, right? And that gets really hard, because now you're saying, okay, what is the triggering event and materiality determination for one, because I'm publicly traded, but I also have a national security mission in contracts with DoD, and I'm considered to be part of critical infrastructure for CISA. So just keep that in mind, because you could be subject to multiple requirements.
Yeah, that's a really important point, and there is a movement to request that the government start to coordinate and deconflict these multiple reporting obligations for exactly that reason, especially if you're a defense contractor, you're part of critical infrastructure, you have the DoD reporting requirements. If you're a publicly traded company, you could be subject to all 3, and they're not, the reporting requirements don't necessarily line up. So there have been some suggestions that there's a common form, and that the government uses that common form, and it doesn't really matter if you report to one of the 3, they share internally. Because we certainly hear that from clients. Why do I have to tell the government 3 times? Why do I have to report multiple times? Why doesn't the government talk to the government? So I think there's certainly a lot of room for improvement, and probably what we'll see perhaps if the CISA reporting requirements are revised. So I'd like to transition next to data breach litigation and privilege issues. When there's a cyber incident or a data breach, forensic investigations are a critical source of assistance to victim companies responding to a cyber attack. Those same reports, however, are frequently sought in litigation if there's, let's say, a class action suit that's brought because a threat actor has compromised a large amount of personal data. So there are a couple different privileges that we see asserted in litigation. The attorney-client communications privilege and the work product privilege are actually separate privileges, but they're frequently combined in just a general discussion of privilege. As its name suggests, the attorney-client privilege covers the confidentiality of communications between lawyers and their clients, and the work product privilege focuses on documents and tangible things that are prepared in anticipation of litigation or for trial. Both apply and are frequently asserted to try and protect cyber incident reports from discovery to the opposing party in litigation. There have been some challenges to the assertion of privilege. Courts in several recent cases have held that the privilege does not apply to forensic reports and communications related to a cyber incident in certain circumstances, and so we're gonna talk about that a little bit here. Rudders was a convenience store that faced a class action lawsuit in 2020 after their payment processing systems were compromised. The plaintiffs sought production of the cyber consultant's written report and related documents. Rudders objected on the basis of privilege. The statement of work was very interesting here. The forensic consultants were retained for the purpose of determining whether there was a compromise, and if there was a compromise, the scope of the compromise. So there's no indication in the statement of work that there was contemplation of this report being used in anticipation of litigation or to assist counsel in providing legal advice to the client. So the court in this case said, this is not a privileged report. This is what they refer to as an ordinary case report. Facts are not privileged. Recommendations of counsel, observations of counsel, those are privileged. This was a straightforward factual analysis and was not privileged. So this highlights that you may not necessarily be able to protect a forensic report in civil litigation, which again we see frequently with large data breach cases. So are you seeing any impact from privilege issues in civil litigation in terms of how forensic responders are engaging with victim companies or with counsel during incident response? And are you seeing any impact on the actual activating of the incident response process because of some of these cases?
Yeah. Sure, so I think there's a trend emerging to retain two different teams. One would be at the direction of legal counsel for the purpose of assisting counsel in providing legal advice, and so that the report itself would be considered work product and protected under privilege. A second retainer would be for an incident response team to come in and do the ordinary course investigation that you've referred to, where they're identifying the compromise and assisting in recovery. And of course, we know that these are very expensive. And this two-prong approach can help you in maintaining privilege over some of the communications and documentation that the forensic team is going to be producing. But at the same time, you have to remember that the legal requirements to make a disclosure apply to the organization regardless of which team makes the discovery. So if your investigative team in the ordinary course is the one that determines that if they're the ones who discover evidence that would trigger a reporting requirement, then you need to make sure you've got plenty of legal review on that to make the disclosure that you're legally mandated to make, and not just relying on the investigation for the legal purposes under the direction of legal counsel, because it doesn't matter, right? Whoever finds the evidence first is going to have to initiate that reporting. So even though it's a good practice to have these two different teams, if your resources allow, you still have to be very careful, because one team could discover something that could trigger your reporting requirements and not be known to the other. So again, I've said it a few times, I'm going to say it again, you have to be documenting who knew what and when, because those questions are going to come later and you need to be prepared to answer those.
That's a great transition. I mean, Target successfully deployed the dual track approach in litigation when it suffered a data breach. And so it consciously retained two different consulting teams. The first track was the factual review. That was the ordinary course investigation that we've been talking about, and that was to respond to and remediate the cyber attack, and that was not privileged. The second track was for counsel to provide advice for possible litigation, and that was focused on giving information to in-house counsel and outside counsel so that they could provide advice to the company. So I think this highlights the importance of thinking about, if you can't afford it, if a company can't afford it, whether or not to have separate incident response tracks. And that's something to think about in advance, be part of the incident response planning process, maybe do your retainers in advance as well with more than one forensic firm to have that ability ready to go if you do suffer a cyber incident. So Erin, I want to follow up with you.
Yeah.
How do approaches to dual track investigation, how are you finding that that's working?
Yeah, so you want to think about how you can mitigate any implications on the impact on privilege, right? So you want to have as much privilege apply as possible where you're legally allowed to have it. And you want to think about, well, what kinds of things can even break that privilege? And we've seen times where making a report to your board could even break privilege. And so that's really something to start to think about, is as you start to make external disclosures or as you make external statements. Jen's been talking about communications, right? Do those communications have something in them that might break privilege? And so you really need to think about reviewing those communications before anything is stated externally, so that you don't break that privilege where you otherwise would have had it or been entitled to it. And you might even consider something along the lines of a taint team. We have taint teams that operate for reviewing sensitive and protected data before it goes to other teams for other purposes, or before it's disclosed outside of the organization. Something like that might help you, especially if you are not an organization that can afford to pay for two completely separate teams. So you might be able to just create your own internal process that will review those internal communications for legal privilege before they've been disclosed externally.
And I think another thing to think about is the distribution list. Copying attorneys on the distribution list is not enough to sustain privilege. but also having a wide dissemination of a privileged review is not helpful either. So you want to have a thoughtful approach to who's being provided with information coming out of what is supposed to be a privileged forensic investigative review. So
And that's a great point too, because courts don't typically like a broad view of in anticipation of litigation, right? Not
Right.
every incident is going to be in anticipation of litigation. So that's going to have to be documented very specifically as well. Which litigation, what kind of litigation, why are you concerned about litigation in your particular set of circumstances, and document that as part of asserting your privilege.
Yeah, and certainly with the large data breach compromises of personal information, there is a very realistic possibility not only of
Sure.
litigation, but of class action litigation as
That's
well. All of which are evolving facts, that are happening during the course of an investigation. Jen, I just want to turn to you. What is your experience with multiple forensic reviews? Can you explain a little bit about what you've seen?
Yeah, so first and foremost, Mandiant primarily works under privilege when we're conducting incident response, right?
Right.
And it's usually around 3 specific scenarios. The number one of which many of you probably have heard, or at least heard a couple times during this conference, ransomware, right? Responding to ransomware, we need multiple teams, especially when it's a large-scale attack, widespread in an organization, right? And again, it depends on the network. It depends on whether or not an organization has gone through lots of mergers and acquisitions, right? So that's where we may be deploying not only Mandiant, but having some of our partners within the cybersecurity community responding as well. And collaboration and communication is key, or else we'll step on each other as we're going through the process, right? The second type of multiple teams where we have assessments going on is the validation phase. For example, if an organization gets to the point where they think they've completed their investigation and they want to disclose to their customers, their suppliers, their vendors, many of those customers, suppliers, and vendors will say, I don't take the self-assessment validation. You need to get a third-party validation. So Mandiant will come in, we'll either look at those internal, conduct a same investigation, right? Or we'll validate and verify what the findings are. Typically, again, it's that primary response. But the third type of assessment that we see happening is especially in highly regulated industries like banking and finance, where there's either an audit requirement or a contractual requirement that you have an independent party. Even if you already have one external firm, right? You have to have a second external firm come in. So making sure you identify who may be those vendors that you call upon. Because in the heightened time of ransomware, there were many occasions where unfortunately there wasn't a lot of bandwidth within the typical response organization. So you want to make sure you're thinking about that. And part of the thing also to be mindful of is all of the outputs will also have implications. So one of which is cost. The actual financial cost, as Aaron Joe mentioned, of 2 teams coming in, right? The second is you have that same group of internal responders who are trying to contain and possibly, work for restoration and recovery. That's answering those questions for the forensic team to go ahead, the external forensic team to go ahead and get started in conducting their response. So, cost is a big piece there. The second one of which is around information handling, right? So we have to also think about, and Aaron Joe mentioned teams, the evidence that we're handling has to be very much controlled and centralized in our tracking. So if you don't already have a system in place, definitely going back and thinking about how would you approach this? Because for most organizations, it's not a matter of if, but when, you may suffer an incident and maybe you're on a 1 or 2 or 3 at the same time. So we hope that you're not there. But and then the last piece, and again, you kind of touched on this, but it's sometimes we come up with inconsistent findings, right? And that becomes very problematic when it comes to the courts and litigation. So as the non-attorney on the team, I always bring in that external legal, bring in your internal legal, your privacy folks, have them help you look at it. Bring in your contract law if you're an organization that has a procurement lawyer on the team, because again, let them give you the legal advice. Don't try to play an attorney. So.
So let's talk about the FBI's role in cyber breaches and in privileged internal investigation. So assume a company has suffered a cyber attack. They're undergoing a privileged forensic review. They want to share information with the FBI, maybe even in a privileged document. How would that work? Can the FBI accept the information? What would you do?
Yeah, so like Jen, I'm not an attorney, but what I'll say is we have an entire unit, the cyber law unit of attorneys that will work with you to figure out a way to share your information in a way that makes sense for you. And most of the things we need are really technical data, IOCs and TTPs and log entries and stuff like that, typically not protected by privilege, but we understand that there's these dual use reports out there. Come talk to us. We're gonna be flexible. We're gonna adapt to your needs, and we're gonna figure out ways like can we get the information through redacted reports? Can we get the information through interviews? I think the bottom line is we want to help. We're willing to take the information in a way that makes sense for you and protects you. And again, once we get the information, you know, if we're approached by regulators and asked for that information, we're going to send them back to you, or we're going to send them back to your outside counsel. The way that we're going to share information that you provide us is going to be in a way with people who need it and organizations that need it in a way that protects the privacy of your organization.
So reporting to the FBI, although I certainly think it's recommended, it's not legally required right now. So can you explain some of the benefits of reporting to the FBI, especially when it comes to potential asset recovery?
Yeah, absolutely. So as I've said, we're victim-centered. Victims of cybercrime are just that, they're victims. And we have a whole host of capabilities to help victims. We want to attribute the bad actor. We want to impose risk and consequence on the bad actor. But most of all, we want to help you. So what do you get when you come to the FBI? You get access to all of our tool sets. We've got cyber-trained special agents, intel analysts, computer scientists, data scientists. We've got global reach through a legal attaché program and very strong law enforcement relationships across the globe. We've got, as you mentioned, Lynn, the recovery asset team that can streamline communications with financial institutions and even assist in recovering funds. And this has recovered hundreds and hundreds of millions of dollars for victims in the past. We've got a cyber action team that can actually do rapid response and provide technical investigative capabilities. And then, you know, there's a host of other resources that really you'll have access to that are comprised of the best from private industry and from the public sector in the government. And, you know, I just want to point out again too that we're gonna scope our investigation, right? If you come to us, we're gonna help in a way that makes sense for you. We're gonna talk to you. We're gonna talk to your outside counsel, and we're gonna limit the scope of our investigation to the incident at hand and be respectful of you as a victim, as we are victims of all types of crimes.
Thank you. So we've talked a lot about some complicated issues, some legal challenges, some forensic challenges. I'd like to close by offering some lessons learned, and I'll start with you, Erin.
So 3 things. 1, consider dual tracking if you can do it. And if you can't do the dual tracking, make sure you have a process in place that would provide legal review over the documentation and reports. And 2, establish clear lines of reporting and decision making, and make sure that you can document your deliberative process. And then 3, that's going to come into play when there are additional scrutiny comes your way and people start asking who knew what and when. You want to make sure that that is clearly documented and that you can demonstrate strong security practices and logical and reasonable and defensible decision making.
Jen?
Yeah, I mean, I think the real key here is collaboration, right? That's very important. And the second part is, you know, making sure to plan. And I said that earlier, but, you know, as Ben Franklin said, failing to prepare failing to prepare will you prepare for you to fail. So let's make sure that we've got an opportunity to look at our plans, our playbooks, our teams that have responders, and who are your external entities that you may need to pull into play to help you navigate the complex landscape of the regulatory and legal side.
Yeah, I know we're running short on time, but you know, I think the takeaway for the FBI is just come to us, come to us early, build a relationship with us before there's a critical incident, and expect that we are going to be victim-centered. We're looking to help you within the confines of what makes sense for you, and we've got a lot of value that we can add for you.
So I'll just close by emphasizing the importance of preparation, understanding your legal, regulatory, and contractual obligations, establishing a relationship with the FBI, and trying to mitigate some of these issues at the forefront. Thank you.